see if we can get this going. I think we might have it going. We might have it going. I see myself materializing here. I see myself materializing. I'm here on YouTube. We're here on TikTok. Now, what I'm going to do is I'm going to go to the questions. I'm going to start getting those lined up. Uh, Again, just in case you're just now getting here, we got 1 more minute. Let's give 1 more minute for the YouTube subscribers. Uh, they were told 12, uh, I'm sorry, not 12, 11:30. Let me get that fixed. Man, we had a typo in there. 11:30, so they got 1 minute, 1 minute to hop on. You got 1 minute to hop on. Um, so let's, just in case you didn't know, my name is Stephen A. Williams, president and founder of the creditrepairshop.com. We repair our clients' credit from A to Z. We also deal with court summons. A lot of people are being sued by debt collectors. If you've been seeing my videos here on TikTok or on YouTube, you see that I'm not a debt collector, but I have access to debt collection portfolios where I see what these debt collectors are buying. They're buying millions of dollars worth of debt on a really on a daily basis, like millions of dollars worth of debt, and people don't even know about this, and they don't know their rights. The big thing is that they don't even know their rights when it comes to dealing with debt collectors who buy debt. But we don't just stick with that. Also, that could be like the low hanging fruit that most credit repair companies can deal with. We also get into dealing with original creditors to try to push to get them to file what's called a 1099-C. Now, you can't force an original creditor to file a 1099-C, but you can express your hardship situation. I'm going to be looking back and forth because we're on TikTok and we're on YouTube, but you can push by expressing your hardship with a debt collector not a debt, well, you can do it with a debt collector, but uh, you can also do this with the original creditor. And I've done this with credit card companies. It doesn't matter the amount of debt. All credit card companies and finance companies and creditors, loans, banks, all of them have a hardship department. And what you could do is you can get with that hardship department, express your financial, medical, whatever your hardship is, and you can actually talk to them. And if they believe that there's no way that they could ever collect the debt or that your situation just meets a certain criteria, and every company has their own criteria, they could submit a 1099-C cancellation of debt where they're just not going to sell it to a debt collector and they will not come after you for the debt. If you go to my website, thecreditrepairshop.com, you will see proof of several 1099-Cs that were successful. One of them that comes to mind was for over $36,000 with a Citibank credit card for a client, where they just did a 1099-C. And that when they do a 1099-C, that is reported to the IRS as income, but you can get a waiver. There's a form that you would be able to get a waiver on, so you don't even have to pay the taxes on that. I just wanted to mention that because the debt collectors are buying a lot of debt. They do have a department within every debt collection company too, where they could do a review and see if you have a true hardship, and they may choose to do a 1099-C also. They don't tell you about that, but if you ever been summoned to court, you will see that most of them will put that line in the allegation saying that they did give the individual an opportunity to express their hardship. All right, now that we have the YouTube, looks like people are coming in on YouTube. Thank you for being here. We have TikTok over here. I'm going to get into the questions. And like I said, we don't just repair credit. We help people get out of debt. We help people who are being sued by debt collectors or even sued by original creditors. We have several victories where we either found errors that original creditors had in their lawsuit, or that there were they broke the law with the way that they wrote the contract, where the interest rate was illegal according to the state laws. You just never know. That's why you always want to review that information. Now let's see here. Now let's get straight into the questions. We have someone here. They said that would it be an original creditor when a finance company, and they might have typed this a little bit weird, but I'm going to try to understand it here. It says, would it be an original creditor when finance company, when doing a debt validation letter, the finance company sold their debt to American Credit Acceptance, then to Credit Acceptance? I'm not sure, but let me tell you the way that we would do it. So whoever has the debt, whoever owns the debt, you would do the debt validation with that specific company. Once it's passed to another company, you would do that. Now, if they try to sue you in court, then you would request that the original creditor, because they're going to be the only ones that would have all of your true documents, you would request that the original creditor, but you do this through the debt collector. And this is how you trap them, though. This is how you trap them. And if you pay close attention to the information that debt collectors will send you, you will see that this is a trap that they do not want you to put them in. When you make that debt validation request in your court summons response, or if you even make it when a debt collector is trying to, send you that 30-day done-in letter, what all you would do is you would request all of the documentation. Now they're going to try to just say, well, we have a couple of statements, and we have a proof of sale where we purchased the debt from the original creditor. That is not good enough. See, a full debt validation where they want you to just think that the validation is just that they have the right to have the debt that they purchased it. No, if it's a credit card, you want all of the information. You want the payments. You want the credits that you had. You want the charges that you made, and you want the PIN code or your signature for all of those. Just think about it this way: if if your account was good to go, and you called up your credit card company provider and you said, there's a charge that I'm just not I'm not aware of, but I want to make sure. And also, while you're doing that, I want to see all of my charges. Do you think that they wouldn't be able to provide you all of that information? Of course they would. When debt collectors buy the debt, if you read the affidavit of sale, it specifically tells them that they take responsibility for all of the error. If there's any errors, if someone filed bankruptcy and they accidentally contact them, if there's something wrong with the account, it doesn't matter. They cannot go back to the original creditor and ask for anything. Everything that they give them on that disk or whatever way that they're giving it to them in the cloud or whatever, that's all they have, and they're not going to get any more information. And also, they're not going to give them all of your records. They're not going to give a third party debt collector the records that they have within their company. They're just not going to do that. So when you challenge them fully on that, and you say, hey, I did not mean, I want you to verify that you can that you bought the debt. No, I want a full validation of the entire account, payments, credits, rewards, interest rates, charge disclosure, full contract. I want it all so I can determine what my next move is going to be. That would be if you're dealing with them in court, but you would just have to put that in your summons response. And that would be if you're dealing with them directly as the original creditor also. Let me just double check some stuff here. I want to make sure that we're good here on YouTube. We have a question here. It says here, hello, what is the best way to bounce back from bankruptcy? I'm really not feeling getting a credit card. Very good question, but you're going to have to start getting some type of credit. You're wanting one thing with, and you have to understand how the game is played. You're gonna, even if you don't get credit cards, you're gonna need to get approved for an automobile, and you can make the payments on there. If you're renting, then you need to get your rent reported. That's some of the stuff you could do. There's several products that are out there that will report your usage of Netflix and your cell phone and all of these other things. You can go that route. But if you're going to ultimately rebound, if you're going to ultimately rebound, you're going to have to get a credit card. And it's not because I would want you to do it, it's because that's the way that the credit game is played. I did not have credit cards. Just to go back a little bit on my story, I started a business with my wife and I back in 1990, grew that business within 4 years, making very good money, ended up getting into money trouble, just like anyone who doesn't have money and then they start to have money, you make the bad decisions. That's how I actually learned about credit repair from making those bad decisions. And so after we, negotiated, paid down the debt, everything to avoid bankruptcy, did settlements, all of that stuff. It took us 5 years from 1994 to 1999 to work our way out of that situation. And it was a blessing because what I did is what I teach people with the credit repair shop is the way that we do it. And it can be condensed because when I was doing it, I didn't really, I was just, let's just try to do this. And if it works, it works. Now I know what works. But I did not go back to having credit cards either. When I was bouncing back, I did not want to have credit cards. But something happened to me when I tried to rent a car. I was in Atlanta, Georgia on a trip. And for years, they had always taken my debit card for renting a car. And they did not, they said that the rules changed. We were like, we didn't know that the rules changed. And thank God that my son-in-law and my daughter was there because we used his credit card. And on the on the way back on the airplane, I applied and got an American Express card. I guess I won't be leaving home without it. But if you're gonna play the game, what I would say is you learn your lesson. You file bankruptcy, you learn your lesson. Don't make the mistakes again. But you're gonna need to have that credit right because when my youngest daughter, went to performing arts school, it was going to cost $10,000 per semester for her living quarters. And I said, well, we're going to pay cash. They said that we don't care if you're going to pay cash, Mr. Williams. We still want to check your credit. And the way you're going to be judged on your credit is what you've been paying on there. So you're going to need to bounce back. I feel you, but you're going to need to bounce back and you're going to have to do it, do what you feel is comfortable. I just told you my story on what I had to do. Now we got another question here about what about a default judgment for garnishment where due process was not done, no service, you need to reopen it. When that happens, you have a certain amount of time. In my state of Wisconsin, you have 6 months. You have to file to have that reopened, and then you're going to have to do your response because some of the times they may not allow you to reopen a case if you don't have a reason that you can win. That goes for civil and that also goes for criminal. If they do not believe that there's some type of evidence that you're going to be able to show them, even though you wasn't serviced, that judge may say, well, I still don't believe that this is going to be worth the court's time. So you need to be prepared. Push on the service. If your state pushes for service, some states only say they have to have proof of service. They can just lay it somewhere, which I don't agree with. But push on that proof of service. And then if they ask for, be prepared if they ask for more evidence, like, okay, we'll accept your proof of service, but how are you going to win this case? Now, if they don't allow it, let me tell you what you need to do for the garnishment is that you need to look at your state laws on number one, the percentage that you can be garnished, and then the exemptions on your garnishment. In the state of Wisconsin here, we have what's called a poverty guideline worksheet. You don't have to be in poverty, but pertaining to how many people you have in your family, including yourself, you may not qualify to be garnished. We've stopped several garnishments that way. Just a simple letter. Didn't even have to go to court. You just send it to them. You send it to the judge. They send a letter and say, we're going to cease the garnishment. It does not make the debt go away. You're going to have to deal with the debt one day, but at least you're going to be able to have that relief and keep your entire paycheck and you start to rebuild your life. Let's go to the next question here. Uh, oh, well, thank you. They said you're a credit to all consumers. Thank you. That was from Ronald. Ronald Lawrence, thank you. Thank you. I'm gonna accept that. Thank you. Trust me, I need that too. Like we all need somebody to say, hey man, how you doing? That's thank you for saying that because that's like that. How you doing, Steve? Thank you. How do you get rid of late payments? Late payments are very difficult to get rid of. The way that we tell our clients to do it, I know other credit repair companies may not agree with it, but we learned a long time ago what the have started doing, especially the credit card companies, is that they will actually move to close the account. Now, on a car loan or something like that, they're not going to try to close the account. But on a credit card open account, they're going to consider that dispute. And if it gets into the wrong hands, they may think that it's an entire dispute. So the way that I would do it is I would, number one, make my pay at least 2 to 3 payments after the late payment. Don't mess up. Then call them up and request a hardship removal of that late payment. Most of them will do it, and if they don't, then you're going to have to just allow that to work its way off, unless you want to chance it and hope that it gets into the right hands to get that late payment removed. And or some of the times they may just remove the late payment and everything before the late payment, or they may remove all the payments and let you just start over. So those are some things that could happen. So be prepared if you challenge a late payment, long as you understand what could happen, that's some of the options that you have available. But the best option is just to make your payments afterwards and then call. And now to speak on something on why it's very important not to miss any payments. Moving forward, if the creditors, the lenders, the banks, credit card companies, everybody start to use the FICO 10 scoring model system. It's been around for a while, but if they start to use it, a late payment is going to hurt you even more. See, right now, if you look at your credit reports, I hope everybody has their credit reports. If you don't, you need to go to the number 3scores.com, grab your credit reports, because what I'm about to tell you, you're going to see proof of what I'm saying on how it can affect you if you make a late payment. Right on your reports right now, it will have 24 months of payment history on there if you've had an account for 24 months. That means that if you have a late payment 24 months or 23 months ago, next month that late payment is going to fall off. On the new FICO 10 scoring system, they are going to start to report 36 months on there. So rather than it taking 24 months to cycle, it's going to take 36 months to cycle. Now, I don't want to get everybody alarmed. Not every finance company is going to move to that scoring system. I'm just letting you know to be aware of it. There are still some creditors that are on FICO 4 and 5 and 7 scoring system, and we have FICO 8 and 9 out right now. So that's determined by them, but I'm just letting you know your scores. One day you can have like a 750. You wake up one day and now you're in the 600s, and you're looking at it and you're going to see that all of that 36 months is being reported. So that's like they're backdating. So if you messed up in the past, now they're backdating that history on there. And we all know why they do that. I mean, this is my reason, is so the companies can have a reason, a justifiable reason to add to charge you higher interest rates. All right. How about late payments on car loans? Like I just said, on a car loan, they're not going to close the account. They might try to wipe all of the history, either all of it or everything from that late payment going back. So you would lose some points, but you would start to rebound after that. The next one here, I was sent a postcard to appear on a Zoom call from LVNV, that's a collection agency, on the 16th. Uh, are you sure you received a postcard? Because I'm about to tell you something. That is breaking the law right there with the Fair Debt Collection Practices Act. They are not allowed to share your information with a third party. You might be asking, how did they share your information with a third party? They just shared that you have to go to a debt hearing, and they sent it on a postcard. You can go online and you can see at the FTC website and the CFPB website where they have actually sued this company, LVNV, for doing that exact thing. Debt collectors are not allowed to notify you by using a third party mailing system. They have to mail that from within their house. And even if they do that, they're not allowed to send it on a postcard. It needs to be in a white envelope. It can have their name on there, but they cannot disclose that. You can bring that up in your response. Now, uh, to make sure that you do this the right way, because you can't really just go at it, show up on that Zoom call uh, because on that date like that. You need to uh, you what you need to do is you need to write the response. So if they sent that, did you write your response to LVNV? The other thing is it says that credit card that was closed in 2016, you need to look at your state statute of limitations. If you lived in my state of Wisconsin, this debt would not pass the legal statute of limitations. We have a 6-year statute of limitation on credit card debt. Everybody listen to me on this, because this is something where this person could be going to court and trying to fight the debt when all you have to do is you do need to respond, but in your affirmative defense you would put that this debt is past the legal statute of limitations to collect on. And when you get that stamp, the court is going to have it. They're going to send it to the debt to LVNV, and I'm pretty sure if you do it the right way, LVNV funding is going to cease that collection. They're doing this, folks. They're going out there and they're trying to collect on debt that is past the legal statute of limitations. They do have a law that says that they're not even allowed to sue on that debt, but people just don't know about it. So, step one, you need to put in your response, because they've already got this court date set up. In your response, you need to look at that complete court summons, and you need to respond to every allegation that those one, two, three, four, five, six. You need to respond to every one of those allegations, because that's what they're saying. That's alleging you did. Some of those are like yeses and nos, because they're going to say that they're suing you in the proper venue. And then you need to put your affirmative defense together. And part of your affirmative defense is everything that you want to question, which is your validation of the debt. And then you also need to put in there that this debt, if you look at your state statute of limitations on that debt, on that credit card debt, and you will see if it's past the legal statute of limitations for them to even collect on that debt. I'm pretty sure that it is. There's only a certain amount of states that have them. There's 3 states. One of them has, 2 of them have 10 years, and one of them has 15 years. You can go to my website, thecreditrepairshop.com. At the bottom, click the blog, type in statute. You'll see the statute of limitations for all 50 states. Column 1 is for like repos or any type of loan, personal loan. Column 4 is for credit card debt. And in some states, the credit card debt statute of limitation is shorter than it is for the statute of limitations for regular debts, for regular loans that are not open end type of loans. Okay, they must have bought it. It is past statute. So you got to do this the right way. What I want you to do, you need to go to our website and click the live chat, because we want to make sure that you do this the right way. You can make all of this stuff stop real quick. Uh, let's see here. Oh, David Fleming, thank you. Thank you. And okay, you're going to do that. It says 5 years for, I think that's Illinois. Yeah. So if you live in Illinois and it's past 5 years, there you go on that. All right. And TikTok, please forgive me. I'm going to have to learn how to see the questions in there. Okay. Someone said about child support. Child support should not be on your credit reports, but that's not going to make the debt go away on your credit report. So all you have to do to get child support taken off of there is, number one, you need to have your agreement with the child support. So if you don't have the agreement with the whoever's collecting the child support, I don't I don't suggest doing it this way, because what they're going to do is they're going to have it re-reported. If you get your agreement with child support, whatever the amount that's going to be, and we got to take care of our children. Not to say that you're not, but I'm just saying that's what we got to do. So step number one, get an agreement in place. Number two, when you have that agreement in place, you use that agreement to actually get that information placed on there as positive. Take that off of there. Make sure that information that's placed on there about your child support is positive, number one, and then you request to have that information removed. And you can use that documentation to get that removed because of two reasons. Number one, it'll be inaccurately showing. And then number two, you're going to make that request on who gave them permission to put that. How did the credit bureaus get that court information to be placed on there? And that using that technique will get that information removed. It'll be off of there, and you won't have to worry about the child support agency trying to uh, utilize a tool to get you to pay because you're going to have your agreement already with them. They're going to be okay because all they care about is to make sure that the kids are getting the support that was agreed upon. So let's go here to some more YouTube questions here. Let me slide this over here. This is a little confusing. Okay, we have we have a question. How long after a summons is issued by a debt buyer do you have to take the case before it is dismissed? A year? How long a summons is issued? Well, when you get a summons, that's they'll let you know when you have to go to court. When you get that summons, some of them will have where it's a lot longer. Some of them will be like you need to show up in court in 30 days or 45 days. So if I'm understanding you right, when they submit that court summons response, you need to, the initial summons, you need to respond to them, and then they're going to usually set up a court date. And it says here, do they have to take the case to court before? No, they do not. I'm sorry, I didn't read that all the way. No, they do not have to take the case to court to get it dismissed. But if they dismiss it, you want to get that in writing because this is a trick that they will try to do. We've had this happen a lot of times, and our clients will say, I'm glad you told me to have it to go to court regardless. We have gotten responses from debt collection companies from the court summons where they said, hey, we're dismissing it. We're going to notify the court. I said, I don't care what they said. I don't care that it's in writing. You show up to court. When they showed up to court and they called their name, the debt collection attorney looked around. And when they saw that they were there, when the person stood up and said, I'm here, guess what they did? They said, dismissed. Told the judge, dismissed. The reason why they do that is because if you don't show up, they're going to ask for a default judgment. And how easy is it going to be for them to get it? They're not going to say, hey, we sent that document. They might come up with a reason and say, well, we didn't sign the document even though we told them it was going to be dismissed. Or they might say, well, we wanted them to be here so we can make sure that we're going to dismiss with our agreement. Whatever they come up with, show up. So we've seen it happen one of two ways, where they'll submit to get it dismissed and they will actually file it with the court. You'll get something from the court. The other way is where you show up and then they'll dismiss it. And then the other way is that they'll try to extend it. Like we've had them where they try to extend people out a year and a half. And that's because they don't want you to show up. And then when that date came up, they showed up, they said, oh, dismissed. Let's see the next one. Once a creditor issues a 1099-C, 1099-C is a cancellation of debt. They can no longer come after you for the debt. That is exactly right. They can no longer come after you for the debt. The IRS will consider that as income. And then there's a form. It's not coming to mind right now. I know it starts with the number 8, but just type in 1099-C debt waiver form, and you'll see the form, and it'll ask you some questions. Most people will never qualify to have to pay anything additional income on a 1099-C. Okay, if you've received a default judgment, is it too late to request this information? It is too late to request information. That was to do an answer. What you have to do is first, step number 1, if you've already received a default judgment, you got to work to get that reopened. And I mentioned that a little bit earlier. You have to go to the courthouse, to the clerk, see if you still are within the time frame to be able to get that reopened. Get it reopened, and then you need to make your response. And again, some of the times they will not allow you to reopen it if it doesn't look like you're going to have evidence to reopen. That's kind of there's no rhyme or reason. That could be pertaining to your specific area, your court system that you're dealing with. If they got a lot of cases, they might, say, hey, we need to, you need to have a good reason to have this reopened. Here's someone here on YouTube. It says here, I'm a bit late. You got a question about repossession. I requested a validation October and UCC Article 9 docs for deficiency 2022, and they have not sent anything I filed. Uh, for repossession, requested, well, number one, I need to know where you're at in the process. Are you in court with the process, or are you just dealing with the debt collector where they have the debt? If you're dealing with the debt collector, then you have to just keep documenting that you're requesting this information. They might not try to send anything. If they go to court, then you would have your evidence that you wanted them to respond to, and that would be in your affirmative defense. That would be responding to the allegations that they have. If you're dealing with the debt collector that purchased the debt, and you're just trying to get them to respond and to get you this information, you're going to have to go back and forth. They're just trying to get you to quit. These debt collectors are buying this debt, and they're in the business of doing it. You're in the business of taking care of yourself and your family. You're too busy. You're not in this business. So they will wait it out. They will wait it out to try to see if you're going to just get tired of it, and then they'll pick a time that they'll go and try to file their case against you. But you have a right when it's a repo. I just did a video on this on YouTube. When it is a repo, you have a right to get that information from the auction statement. You want to get the original contract to make sure that they did not do what American Credit Acceptance has just, I don't want to say admitted to, but they just settled a major court case where the auto dealers were changing the contracts that they gave to American Credit Acceptance. And people were paying on their cars, and then they paid 36 months or 60 months, but they still owed on the car when it was supposed to be paid off. So you have a right to get the original contract from what was turned in to the original creditor. Even if a debt collector got it, you have a right to get that. You have a right to get the auction statement. How much did the car sell for? Right now, used cars are selling at a premium. The dealers want them because they can't get new cars as fast. Your car could have sold, if it's in good shape, it could have sold for a lot more than you think it would sell for. And then you just want to just get everything, checking if they had any type of credit insurance where they would pay the payments on the car or pay the car off if you had a subprime loan. These are some of the things that they sneak in to be able to protect the dealer from any chargebacks that they might have. But if you're still dealing with the debt collector, you just have to go back and forth with them because they expect you to quit. Here's one here that says CFPB and the BBB complaints, and they basically said that they won't remove it. What should I do? Let's see, what was yours from earlier? Refresh me on, okay, it was from the repossession. Keep moving on it. Make sure that you review how they're responding back to you. This is something that I had learned. There could be a specific question in the response. Like when we send something out, the response that our mind is focused on is delete it, or we're going to take it off, or we're going to stop collection. But you need to read their documents fully, and then that way you can respond to them. Maybe there's certain things that they want a way that they want it responded. One of the things that I saw in a court case where an individual actually lost a court case was that it was all because they didn't respond to the to the debt collection company using their documents. One of the things that CFPB does allow, and they have the creditors and the debt collectors upload their forms. If you have ID theft or if you have an issue like what you're going through, this is a sneaky thing that they do. They upload it to CFPB, and if CFPB approves it, any disputes that you have, any requests that you have, must be submitted on their documentation. We went through that with a client with Green Tree where they had ID theft against them. We had proof of the ID theft, police reports, everything. They didn't want to remove it. They were even trying to say that he still owed it. And then we got a call back from them saying that it is ID theft, but they didn't want to remove it until we actually had the client fill out the documents that they had sent. They wanted it done on their form. And then when they said that, well, we did email in the form months ago. When he looked into his spam, that form was actually there. So that could be something. Read it very good, and you'll be able to see if that might be one of the issues that you have. So it says, I did a credit relief program, and now I have all the settlements and closed accounts. I got laid off due to COVID, and I have no choice to do that. I understand that. How do I get rid of that? So let's see. So it is for the repossession. You just got to keep working on it. I know that may not be the answer that you want. You need to just keep working on it. Respond to them. Read it thoroughly to make sure that you're responding to them the right way. Keep requesting all of the documentation, and then anything that you have, you stack that up and send that to all three bureaus to make sure that they know what's going on, and then you can get that information will get removed. Sometimes let me just say something real quick too. Sometimes it takes a lot of back and forth. People put stuff out there. Hey, 30 days, do CFPB. We already know that what's going on with that. You did everything that people are claiming that you got to do. Some of the times it just takes work. It's like working out. It's like going to the gym. The person who does it over and over and over again is going to be in the best shape. And just like what you got to do, I wish that there was some fast way, some McDonald's way to tell you how to get it done. You just got to keep working on it and doing it. And what I tell all of my clients is that once it gets done, all of that time that was in back that you kept doing all that work is going to like melt away and disappear. So what I want you to do is I want you to focus on the goal, do whatever is required, review every document that they have. Maybe you missed something in the way that when they responded to you, maybe you missed something. It could be a little sentence where they're like, hey, if you had done this right here, and you're saying that you had a hardship with COVID, that you had the hardship, ask them about the hardship department. Was this reported during that period of time? Because some of this stuff was not supposed to be recorded due to federal law when we under the national emergency, and also for specific states. So that brings to my mind, why don't you check with your state to see what was allowed to be reported on your credit reports during that period of time. See, some of the times all we got to do, we got to craft it to fit what was, like what the whole situation was about. Yours was about what was going on with COVID. We were in a national emergency. Certain items were not supposed to be reported, like medical bills, all types of stuff. So look at the relief that you might have with that, craft up that letter, get that submitted over there to them. Let us know what happens with that. Next question here on YouTube. I got a ton of inaccurate information on mine, and they won't remove it. That's a hard question to answer. I think I just answered it. You got to keep fighting it. Just keep on fighting. That's what you got to do. You got to keep fighting. Let's see here. Sorry about the scramble on there. I don't know. I'm gonna figure out TikTok with the live. I apologize for that, but I'm gonna figure that out. But go to YouTube if you get a chance. And to my channel, the Credit Repair Shop. It is recorded on there. Here's another one here. Individuals stated that they're being sued and that they're on Social Security income, that's their only income. You could literally stop the case right in its tracks by notifying the plaintiff attorney that you're only receiving Social Security income, and they will not continue coming after you. Maybe they might try to get the default judgment just in case you win the lottery or something. You never know. That's going to kind of be up to the debt collector. But for the ones that we've been a part of, they just choose to stop the entire process because it's like, what are they going to get especially if you're on retirement income? Really nothing's going to change. If you're disabled and you might have a limited disability that's going to be changing over the next few years, they might either choose to wait and they won't dismiss it with prejudice, or they might go ahead and get the judgment and just say, hey, we're going to wait it out. We think that this person's situation is going to get better. Now, another question on here, it said that, and this was something that happened earlier in the week to an individual when they reached out to us. They said that their bank account was attacked where the debt collection company, they woke up one morning, money was gone out of their bank account. And they had asked, what can they do? The first thing that you need to do is you need to call your court clerk and see how you can get that money either put back in there, and it would just be where it's on hold, where no, you won't have access, they won't have access. If you have documented reasoning on why they should not be able to get access to it, you should have that prepared when you go down there. Uh, but you need to that would be step number one. A lot of people try to do other things. That would be step number one. You got to see what are the rules in your area to be able to get that money turned back into you, because it is not fun. I hear when people email, they'll say like help, or they'll call us and be like help. They took the money out of their account. They called an attorney saying that they could, giving them the same information, but they felt that the attorney was going to try to point them towards doing bankruptcy. Every situation is different. I can't give you legal advice on that. Every situation is different, but if that happens to you, be prepared to be able to show a reason why you need to have that. Well, number one, get down there. Don't delay. Get down there. See what rights you have to have the money put back in there. Maybe they broke some rule. Maybe you wasn't serviced. Whatever the reason is. And then there are some states, the states that we see this happen a lot in, are the states that do not allow wage garnishment. Like the state of Texas does not allow individuals to have a wage garnishment out of their check. But they do allow debt collectors to go in there and look at the money, to go in there into their bank account and levy the money. So, I mean, and that could be like a shock, because at least if you were being garnished, you can negotiate an amount that you can afford, or they do whatever the percentage that's allowed by the state. And the individual, they wasn't a client, they were just asking these questions, and they were saying, well, how did they even know that I was going to have the money? The way that they find out is there's these services that TransUnion, Equifax, Experian provide to people. It's called skip tracing. And basically what they do is they want to, so say you owe them money, they've got a judgment against you, and they want to see your pattern, how you're living. They can use this skip tracing information to find out everything on you, your job, everything. But that's not good enough. They want to know if you got the money. So this is what they do. They look at the payments that you're making. Say you're paying on your mortgage. Say you're paying a credit card. Say you're paying on your house. And they look at that pattern. They're like, oh, on the 25th of the month, they start getting their money together to make their payments on their mortgage. If your rent is being reported, your rent, maybe your cell phone bill, all of the stuff is being reported on there. And they're like, okay, they got their hands rubbing, and they're like, okay, we're going to strike the bank account on the 25th, because we know on the 25th they start lining up, getting their money ready, and for the first to pay their bills, we're going to strike on that date. Or they'll just look at your paycheck patterns. Everybody's getting direct deposit now. They'll just look at your patterns on with the company that you work with. They'll get the company name. Oh, they pay everybody on the 1st and 15th, or they pay everybody weekly. And then they'll just have that order uh, uh, placed through the court, take it straight to your bank, and your bank doesn't even notify you. Your bank will not notify you. You might even try to make a deposit, and then you will say, "Well, I want to withdraw some money." They can take your money, but they can't give you any of your money back. It'll say frozen on there. I mean, that is like one of the most debilitating things that can happen to an individual. I've had that happen to business associates where they, called and they were like, "What can I do? What can I do?" I mean, they need their money to run their business. So this is something that if you live in a state that does not allow for your wages to be garnished, you need to protect yourself. There's certain ways that you can protect yourself. And then if you live in a state that you can be garnished, but you have a business. We see this happen where they do it with businesses. Uh, let's go to the next question here. I'm going to see if we got any questions on here. Uh, just some with the child support that was on there. Let's see here. Got one. Let's see here. What's the next one? Currently in court, still owed. Owed was $400. Credit limit went to arbitration. Uh, so we have an individual. Some of the times when you're being sued, the debt collector will try to push to have you go to arbitration. They don't want you to have the opportunity to fight it in court. And when you go to arbitration, you have to be very careful because when you go to arbitration, it's going to mainly be on the amount of the debt. It's going to be a negotiation on what you're gonna pay and how you're going to pay it. The way that you would have the most chances of success is to just outright respond to the court summons and have your day in court. At least you'll have a chance to where you have the chance that the judge could dismiss it, say that you won, or the debt collection company could say, "Hey, this is not going to be something that we want to fight, and we would just like to have this case dismissed." And just so you know, I mean, not to say I don't want to say like somebody's value is over another person. All of us have equal value, but this is something that does happen in these debt collection cases is that they will send an attorney that's not really like a litigating type attorney. It's just someone that's kind of just signing documents. You know, maybe an attorney, let's just say that someone that's up and coming, like they're making a name for themselves. And so they'll give them this type of caseload work where they got to sit there all day, names are being called, and they have a number of cases that they're going to be having to sit in for. And so, like with my situation that I went through in the 90s, um, when I had asked for a full validation of all of the information, and I didn't even really know what it was all about. I was just saying that, hey, I did not have this amount of debt. It was they claimed that I owed $4,500 from a credit card that was from 1988 when I was in the military, and I was barely making any money in the military. And I believe it was only $150 was the total amount of credit that they gave me. And I said, I want to get a I want to know everything about this debt. Now, the judge allowed me to ask it that way. Nowadays, it's going to be iffy. I just said, give me everything. They came with a big stack. This was, remember, computers wasn't like it was in the 90s like it is now. They came with a big stack. Everything was redacted, and they you know they but when they I made that request at the first hearing. That was with the up and coming lawyer. When I came back and they had the whole stack, it was the main attorney, Roush and Hornick. If you've ever been sued by them, they're like, I was back then when they were all coming up. That was the debt collection firm. They're in like I think 40 states now, but this was they're based right here in Brookfield, Wisconsin. They sent him in that time, and then I negotiated with him and got the debt, paid off the debt for $500. The judge said, "Man, you're lucky." What I didn't know at that time is that the debt was past the legal statute of limitations for them to even be able to try to collect it from me. And I did not have that amount of debt. So they probably bought that for a penny. They made $500 on me. I just wanted it to go away. I was young in my 20s, didn't want to deal with that. We have a question right here. I received a judgment from an attorney hired by Discover. I had a legit dispute of how they came up with that balance. I was ignored in court, no evidence presented. Can I file a motion? Yes, and lucky that you're here. Let me tell you what you need to do. This is what you need to do. I hope you're still here. That's freedom will prevail. There was a recent court case that was just settled with the CFPB on Discover. Discover card, they were using an attorney that was robo signing and not giving all of the documentation to prove that individuals would have to pay the debt, and that was from an original creditor. American Express, Discover, and Capital One are known for keeping their debt, hiring an attorney to go after it. You need to, if you go to my YouTube channel, type in, it was a recent video, maybe a week ago, but type it in, Discover Card. Uh, I just made a video on that. They all of the collections on those were all supposed to be voided. And you might be saying, well, why wouldn't they just follow the rules and void it? Debt collectors do that all they do it all the time. They think that it's up to you to find out that information and have it voided. Yes, they will do it for a number of active ones that the CFPB knew about, but maybe they didn't know about yours and they slipped that through. That even happened with Santander. They were selling the Santander was a subprime auto loan company, or they still are. They got sued, major hundreds of millions of dollars they had to pay. They had to give people their card titles, all type of stuff. But one of the things that we caught them doing is that they were selling some of the debt to debt collectors. And there, it was wrote in the settlement that the debt collectors were supposed to send that debt back. But the debt collectors like, man, we can make this money. People won't show up to court. We can make that money on that. And so that's why you do that right away. Yours could be included. And then if it's not included, I would still include the information that they had in there in your response, and then you build your case around the documentation that they provided to you. Now, because it's an original creditor, and you had your legit disputes of how they came up with the balance, you have to put that in your response. Uh, Not saying that you didn't do it, but when you respond to the court summons, you got to put that information in your affirmative defense, and you also have to put that on the line of where they put the credit card number and the balance that they claim that you owe. If you get your court summons documents, you will see that specific line in there and their allegations, and then you have to come back around in your affirmative defense and put your response to that in there. Works if you have a legitimate dispute. I I don't want to say 100%, but it works a lot of the times, especially when you have a legitimate dispute that you can that the court can follow and identify. You don't want to get them saying, well, because of this court decision and that judge. No, it has to be specifically based off of your information with your specific account. Have the debt collection lawyer or the discover lawyer going back and forth, because what they're going to have to do is they're going to get your answer, and then they got to go to discover, and discover is going to make determination. Hey, okay, it was a dispute or whatever, or it wasn't a dispute, and then you're going to have to respond back from what they say. A good thing that you're still with the original creditor with the discover. Potentially, if you can get it back open, that they could choose to file a 1099-C if that would be, if it fall into that category. And yes, go ahead, file a complaint with CFPB. This will be one that they will probably follow back up with you. This will potentially be one that they will follow back up with you, because they just recently settled the cases with those. I want you to include in your response, in your complaint with the CFPB, that you believe that that number one, they're not responding to your disputes, and that you would like to have this scrubbed to see if this was included in the recent settlement that they made with the attorney that was representing Discover and the other credit card company, but just mention Discover. All right, we're getting ready to close it out. It says here, yes, it was redacted. The account number was redacted, and I disputed the balance limit included in my original answer. Okay, I'm not sure on that. I would have to really see it, but you would need to ask to have it reopened. And if the judge made a decision on it based off of your information, if it was put together properly, if they made a determination on it, they may not want to reopen it unless you had that new evidence. So do the CFPB first, and then get them to get a response. See if you were potentially included, and then you could for when you go back to the court to have that reopen, you can include that information. But you got to move fast because you don't want them doing any type of wage attachment on you. Uh, what does redacted mean in credit? Sorry, don't know. No, that's not Carolyn. That's not a bad question. What you'll see happen when a debt collector buys a debt, they do not have the complete account number. It'll just be redacted, have a black line, just be redacted. It'll have the last four numbers. You have a right. You have a right to see that full account number so you can review to make sure that this is the appropriate account. What if you had three accounts with them? What if you had two accounts with them? What if you had five accounts with them? What account is this specifically for? You need all of the information so you can make an educated decision on how you need to follow through with this whole case. Even if they're sending that with the in the Dunning letter, the 30-day letter, you have a right to get that information. You see, think about it. Think about it this way. Think about it this way. This is what truly makes us different from other companies that might be doing this here with helping people with these court cases. Is that you're not denying anything. You're asking for information. What court would not allow you to ask for information? If you give them, if you say, hey, I'm not denying this, I don't have enough information to admit or deny, but get me the information so I can review it. So you're in a way, you're setting them up. Get me that complete account number. If it's a debt collector, they won't be able to get the complete account number. If it's the original creditor, they will be able to get the full account number. And then if you have legitimate disputes with the original creditor, you bring up those disputes. And if you can get that back and forth so muddled up with that back and forth with the plaintiff attorney who has to go back to the original creditor, the plaintiff attorney is like, hey, I'm getting paid hourly anyway, so it don't matter to me. They're in a better position than the debt collection company. So what they'll do is they'll be like, hey, they had a question on this. I need you to get that to me because I don't want to go in court and say something wrong. Original creditors, some of the time they make a decision, hey, don't deal with this. It just depends on the situation, especially if you include in there, I need all of my information from the charges, and there were specific disputes that I have with your account. I want to get all of that information so we can go over it. They get that over to the plaintiff attorney. You review it. You find something else wrong with it. They get it back. It goes back to them and back over to them. That original creditor might say, hey, this might not be the one. We don't want to be sitting here paying you hour after hour after hour. Go get the one over there that's not responding, that's just running. Let's go focus on the default judgments. Let's focus on those. All right. Hey, I appreciate everybody's time. Uh, I know my voice is loud. My daughter, she'll tell me, hey, you be screaming on there. I'm just telling you, I have passion for this. This is like what we do. Uh, it gets my juices boiled when I come into the office. I come into the office and early. I get up at 4:30, 5 o'clock in the morning, and I'm ready to do some work and help people. I have a complete staff here, full-time staff that does the work. Like I say, I'm the voice, but they do the dirty work, the back and forth. We get on the phone, we do all of that stuff. So if you need to speak to someone, you know they're here. We answer our phone. The way that we do the customer service, we take in the calls, we line them up, and we call people back. That's the way we do it. But it's full time people here in my office. If you're in Milwaukee, Wisconsin, you want to be a client, you can come to the office. You'll sit at the conference table, and you can come on here and testify that we're a real company. And everyone, I appreciate it. The credit repair shop is what it says. The credit repair shop all put together on my TikTok. Uh, I really appreciate everybody for being here. I really appreciate the questions. Your questions uh, uh, make me a better person. Your questions make me want to study even more and come up with new ideas. Uh, when we get when someone wants to be a client with us, we review everything. We make sure that there's a process put in place. We have a staff that just works on that, and we don't promise overnight success. We promise hard work. It will get done. It will get done. I wish that I could tell people when their specific situation will get done, but it just doesn't work that way. And we know this in life. We know this in life. So I'm gonna leave you with that. Is that we know this in life, that even though some of us are, in a better position than others, some of us have a lot of stuff going for us. Some of us seem to have a harder time making it through. But we all have equal value. We all need to be treated with respect. And I want every one of you to have a better day. Like, wake up in the morning and just tell yourself today is going to be a great day, and make it a great day. Don't have other people tell you that, to try to manipulate your mind to tell you how you need to feel. You tell yourself how to feel. You tell your body how to feel. You tell your body how to react. You tell your body everything that you want, and you will see that things will start coming into your life. If you have a situation right now that is difficult for you to get through, I want you to start focusing on the ultimate goal. And then you focus on doing the work. Don't focus on the ups and downs of things that go bad in between, because that's going to all disappear when you get to that goal. All right, I'm going to leave y'all with that. Thank you for your time. This is Stephen A. Williams, president and founder of the creditrepairshop.com. Thank you, TikTok. Thank you, YouTube. And I got to close out on here. I'm going to close out on in my stream there. And I got to learn how everybody here on TikTok, I really appreciate it. I really do appreciate it. I still got to learn everything on here, but I really do appreciate it. Let's see here. How do I close this out? Sorry that you had to sit here looking at me while I'm learning to close this out, but we'll get that. And I'm going to be putting more videos here on TikTok. I'm going to be putting a lot more videos here. If you missed it, I think that there's a way that you can go back through and uh, and see how to watch this again. Let's see here. Still trying to work this out here. I think it's the way to do it. All right, I think we're going to close it out here. Crazy. One of the things that I like here on TikTok, they have the DJ where the people are DJing, and I am a DJ. So I got it here. I'm going to be ending now. I appreciate everybody for watching. Thank you for your time. This is Stephen A. Williams, president and founder of the creditrepairsHop.com. Make sure you go to my YouTube channel, The Credit Repair Shop. You'll see my face on there. You can watch those videos. I have some very good information on there. Mm-hmm.